Here are your Court News Ohio top stories in 5 minutes.
The Ohio Supreme Court on October 1st ruled that a person accused of DUI can challenge the accuracy of specific results from the breath analyzer machine used to conduct a breath alcohol test. The court noted in its opinion that the Ohio Department of Health director is responsible for selecting Intoxilyzer 8000 machines that determine an individual's breath alcohol concentration, and that an accused is prohibited by state law from attacking the general scientific reliability of those tests. However, the court continued in its opinion, an accused is not prevented from challenging specific test results or whether a machine was operating correctly during the test. The court's unanimous decision affirmed the First District Court of Appeals judgment.
The number of cases going to trial in Ohio is declining, and the state has seen 5 consecutive years of fewer new cases filed, according to figures recently released by the Ohio Supreme Court. The figures come from the 2013 Ohio Court Statistical Summary, where it illustrated that with the exception of traffic court cases, filings in most case types across all levels of courts are lower. Last year, 2.6 million cases were filed in Ohio courts, and the courts experienced an overall 3% decrease in cases filed in 2013 compared to 2012. The Supreme Court's case management section compiles the statewide statistics using data that Ohio courts are required to file. Chief Justice Maureen O'Connor said the report is useful to courts by helping them better allocate resources and assist in the efficient administration of justice at all levels of the judiciary.
Trial lawyers who use social media such as Facebook, Twitter, LinkedIn, and Instagram to pick out jurors now have the American Bar Association stamp of approval. The ABA released Formal Opinion 466, which allows lawyers to review jurors' internet presence. It's not anything new for most attorneys, but the recently released opinion ethically allows attorneys to do this in the courtroom. Social media is just another tool in the shed for Columbus attorney Steve Chapelier.
We learn something when we're in the courtroom and we can look at them and hear them and we can ask them questions, but now we can get some background information and learn more about what biases or prejudices they may bring to a case.
Chapelier said the ABA opinion makes sense. It allows lawyers to use social media if the information is already public, but it doesn't let attorneys friend a potential juror.
It's a good common sense approach which protects the privacy of individuals. It eliminates the ability of lawyers to go in and use fraud or artifice to pretend to be someone else.
Chapelier said most jurors don't even know attorneys look at their social media profiles.
Frankly, we don't want to leave footprints because prospective jurors are, I suspect, not excited about the idea that lawyers are looking them up before a trial.
Case in point, potential jurors Brandy Jennings and Jonathan Samuel. The two were not selected for a jury trial during their week-long stint in Columbus, but just found out that their Facebook and Twitter accounts could have been used during their selection process.
It didn't cross my mind that they would look at Facebook or anything like that. It would make me feel some type of way, like, why did they pick me from looking at my social media pages? What did I put out there to make them want me to be on the jury?
Samuel said people should just be mindful of their posts.
You should be aware that there are a lot of different entities that can look at your Facebook, your Twitter, your Instagram. That's personal responsibility. You got to know, hey, what I'm posting right now can be seen by other people. I mean, that's your personal fault if you put something on there and you don't want other people to see it. You got to be careful.
Chapelier said people can avoid all this just by adjusting their privacy settings.
If you want to restrict it to just your true friends, fine, that's easy enough to do. Otherwise, it's all fair game for lawyers during the jury selection process.
Under a new state law, the Ohio Supreme Court can now reimburse counties for a portion of compensation paid to acting judges appointed to serve on municipal and county courts. The Ohio General Assembly reinstated laws permitting county treasurers to seek reimbursement from the Supreme Court for the state share of compensation paid to an acting judge. The legislation also clarified the formula for calculating the compensation payable to judges assigned by the Chief Justice. The reimbursements are retroactive since July 10th. More information can be found on the Supreme Court's website at sc.ohio.gov.
That's a look at Court News Ohio's top stories. Visit courtnewsohio.gov for the latest headlines on Ohio's courts. You can also follow us on Facebook and Twitter.